Hi, I'm Ashley with Campbell. Thanks for investing your time to help your community be a great place to live. Before you watch the video, make sure to click the subscribe button so that we can help you make educated decisions as a board member.
Good morning, everyone. Thank you for tuning in here today. I'm happy to give you this presentation. My name is Dan Wasserstein. I am an association attorney at our firm. It's me and 3 other lawyers. All we do is represent associations, and we really pride ourselves on diligence and responsiveness and accessibility. And I know many of you probably work with me or have worked with me. We're happy to help our associations, and I'm also happy to provide courses like this where I can help educate managers and board members so that they can save themselves some money on calling their lawyer, because they will have a lot of extra knowledge on something that every association touches upon, which is violations and possibly fining as well. So we're going to go right into it. I will at the end take questions. I know there's some Q&A. We'll address those at the end if they're not addressed by the presentation. And I'm happy to take those questions. And of course, if you have anything else that comes up in the interim, or I should say after the presentation, and your community would like some assistance with this or anything else, my information is below and the presentation will be available to you. So getting started here. So we're talking about, again, the violation and fining process. So what are the things that your owners, your tenants, your guests, what do they have to comply with? Well, as you can imagine, those are the Florida statutes. Predominantly, if you're in a condo, 718, and if you're in an HOA, 720. If you happen to be in a cooperative, that's 719. And then also Florida statute 617 is what governs not-for-profit corporations in general. But it's really those other ones that I mentioned, 718 and 720 respectively. Of course, your declaration, if you're in a condo, it's a declaration of condominium. If you're in an HOA, it's a declaration of covenants. Then you have your bylaws. Your bylaws really are things that govern more procedure about how you hold your meetings, what the officer positions are. So a lot of times the bylaws don't contain substantive information as far as things that might result in a violation, but some of your older bylaws, they did stick that stuff in there. So again, it might be something you need to enforce by way of violation and fining. And then rules and regulation. Rules and regulations are a sort of more minimal version of your declaration. So those are the things that generally contain the provisions that your people need to comply with. Now, within those, and we're talking about the governing documents now, predominantly, the things that we see most commonly need to be enforced and need to be regulated are what you see listed here. Architectural standards and alterations to the parcel. That's going to be more common in HOAs. So where someone wants to install a pool or expand a driveway, things like that. In a condo, you may have some control over what people do inside their unit as far as renovations, but it's somewhat uncommon. The only thing I see commonly is if people want to do anything on, like, let's say a terrace or a patio or a courtyard in a non-high-rise type of condo. Sometimes those things are regulated. Then, of course, we come into restrictions that we all deal with, pet restrictions. We all know we all have to deal with those. People that don't walk their pets on leashes, people that don't clean up after their animals, people whose animals are causing nuisances, they're barking incessantly. Those are the sort of things we deal with. And some of those things I just named can even be enforced where the animal is not a pet, but a support animal. And I know everyone probably rolls their eyes when they hear about emotional support animals. You know, it's sort of an abused thing that people take advantage of to circumvent your restrictions. But the only restrictions they can circumvent on those are breed, height, weight, and paperwork restrictions, I'll call them. Otherwise, cleaning up, leash laws, all that still remains in play for even support animals. Of course, then restrictions on leasing and sales. You know, a lot of communities will have specific procedure. They may require approval before someone can buy or lease a property. Parking and vehicular restrictions. You may have provisions that say certain vehicles are not allowed in your community. There may only be a limitation as to where people can park, that they can't park on the street. There may be a decal system that you can park here and not there. So again, those are things you may commonly run into violations on. And then probably the most common one, I would say, are nuisance and noise complaints. Basically where people are disturbing others in a various way, whether it's, you know, smoking things they shouldn't be smoking, or in places they shouldn't be smoking, or having a party, or just generally being loud and disruptive, or combative with everyone. Again, those kind of fall under nuisance complaints. So these are the types of things that commonly we see associations want to enforce against from their governing documents. So now we'll talk about enforcement to begin with. Of course, the board is charged with the responsibility of uniformly enforcing its governing documents. The word uniformly is key there. And we'll talk about this more later, but it is important to treat everyone the same. So if you're going to punish one person that has a pickup truck that your documents don't allow, you need to be enforcing that against other people that have similar vehicles. Otherwise, it creates a defense, which we'll get into later. And then, of course, not just uniform enforcement, but timely enforcement. You don't want to wait several months, let alone years, because after the passage of a certain amount of time, there are waiver arguments and even statute of limitation arguments where someone may be allowed to have the violation openly. They may say, yep, I have, again, I'll use the truck as an example. I have a truck that's not allowed, but I've had it for 10 years and you can't do anything about that anymore. And we'll talk about that more towards the end of the presentation. So again, when it comes to enforcement, uniform and timeliness are very important with regard to that. As far as the condominium fining process, it's found in the statute 718-303. And it says the association has the authority to fine an owner or the owner's tenant, guest, or invitee for failure to comply with the governing documents. The authority to fine arguably does not have to be provided for in the documents, but it absolutely should be to avoid a challenge. The reason I say it may arguably not have to be required, these statutes, and it's the same as the statute for HOAs, several years ago, they used to say that if the authority exists in your governing documents, then you can levy a fine against someone. And that first part where it used to say, if the authority exists in the documents, that was deleted several years ago. So arguably, you don't necessarily need authorizing language in your governing documents, but I would highly advise, even in just the rules and regulations, which the board can vote on, if you don't have fining language anywhere or suspension language, I would definitely just have the board vote to put it in there. It just takes one argument away from people who are fined, because if they say, show me the authority, rather than having to make this legal argument, you can just say, boom, here it is in our rules. So again, that's for communities that don't have it at all. And again, it's the same thing I just discussed with HOAs. The HOA has the authority to fine an owner or a tenant, guest, invitee for failure to comply. Again, the same legal provision I mentioned earlier. I would advise that you put the authority into your governing documents. So we've talked about now enforcement. We're going to go into now how the actual process starts and how the statute wants it to be governed and how they want it to work. So initially, a potential violation of the governing documents is brought to the attention of the association by someone. Usually it's going to be management. Some communities have the manager walk the community. Some of them, there's a committee that does that. So oftentimes it's management through staff or assistance of others that are going to discover or bring this to the association's attention. It can also be, though, often unit owners, tenants, board members, or committee members, other people in the community that say, hey, I saw this or that happening, and that's how it's reported. Now, not only is it important to gather the information, but it should be reviewed and vetted. Especially if it's coming from a unit owner. We've had instances where unit owners have reported an existence of a certain circumstance, and the manager has gone out and said, yeah, that doesn't exist. So rather than just sending someone the notice of violation, you do want to screen, especially if it's coming from residents, you want to screen what's coming in by way of violations before you send out a notice. But once you've done that, it's been reviewed, and you believe that there's merit to the violation. Traditionally, a notice is going to be sent by the board identifying the behavior in the rule or covenant which it violates. It's good in those to put the person's name, of course, their address, a detail not only of what happened, but perhaps a snippet of the rule or covenant that it violates. And the best thing, if it's not something like, let's say, a party that happened and is over, but let's say it's a vehicle that's parked in an illegal manner, or in an HOA, a dirty roof that hasn't been cleaned, it's best to take a photo, and if you can, put that photo in the letter, because then it does a lot to take away from the person who's receiving that letter their ability to deny till you die, right? I have people that no matter how many letters we've sent them, that wasn't me, I didn't do it. But then guess what? When we say we have you on camera, or here's a photo of you, or here's a photo of your car, all of a sudden it's, oh, well, I must have forgot. It just takes, again, another argument away from people to avoid them potentially refuting what otherwise is a valid violation. Now, of course, look, if the violation is the nature and type that it's continuous as opposed to a one-off type occurrence, then it's customary, most associations will give that person opportunity to cure. So let's say in a condo, someone has piled up junk on their balcony, tires and other, stacked furniture that's not really shouldn't be out there. Then those sorts of things that's continuous. That's not like a party that happened and it's over, or a vehicle temporarily parked illegally and then gone. This is ongoing. So if it's an ongoing situation, customarily management will send the individual a letter that gives them some window of time to cure the violation before the board will consider any sort of punishment by way of a fine or even legal action. So that's normal. If it's not continuous, again, if it's one of those things I just mentioned, for example, the best example is a loud party, then you don't need, there's nothing to send a cure letter or a warning letter, because the thing has happened and it's over. So, you could send a letter that's like a don't do it again type of letter, if that's what the board wants to do, and that person could be considered warned. And then the next time there won't be such a letter. But again, that's up to you. I will tell you why it's customary to send some of these letters, especially where it's an ongoing violation. It is not in any way required to give these violation letters, these warning letters. So just be mindful, but it is customary practice to give an opportunity. So now let's say, whatever the violation was, whether it was a one-off or it was one of these other ones that you gave them a chance to fix and they didn't address it, Then normally what will happen next is that the board will schedule a meeting, and at that meeting on the agenda, fining, and not only just fining, but fining of specific lots or owners will be listed on the agenda item. And at that board meeting, the board, which is going to be held on just 48 hours notice, doesn't need to be held on any other special notice, with fining as an agenda, at that meeting is when the board is going to levy the fine. And that's what the statute used to have, a different procedure that this could all be done by a committee. That doesn't exist anymore. The board has to levy the fine. The committee has a much more limited role now, which we'll get to. So if you're getting to that point, the board sets the meeting, they list this as an agenda item, and at the meeting, they can go through each person individually, or they can vote on all the listed violators as a whole, and make a motion, which would be seconded, and vote to levy a fine. Now, let's say there's 5 people and you want to fine all of them $100 each per day because they're continuous. Someone could make the motion that just says, I move we fine all 5 people the $100 a day, up until the $1,000 max. Or you could go one by one if you have different amounts and different issues that you feel you want to address individually. So again, some boards will do it as what we call an omnibus motion, where they just, let's do all of it in one motion. Some do it individually. Again, that's up to you. Another good thing that boards use as a tool for them in this process is they will vote before they start fining people. They will vote on what I call a menu of charges. So for each type of behavior or violation, leaving out the trash cans will be $50 a day. And then maybe having a dirty roof or a cluttered balcony will be $75 or $100. That way, the board, they don't have to think back and say, well, what did we fine, Bill and Judy for a year ago when they did the same thing? You'll have a set amount, and no one can say, well, you fined Bill and Judy a year ago 50, and now you're trying to fine me 100. That way, instead of having that disparate treatment, everyone will get fined the same. So having what I call a menu of charges is a good thing for you to vote on as a board. However, the misconception with that is a lot of boards think if they have that menu of charges, that means, well, we don't have to have a board meeting anymore. We've adopted these charges and we can just skip right to the committee process. I will tell you, if someone who gets fined hires a lawyer, the first thing they're going to do is attack that issue. Their lawyer is going to say, show me the board meeting where you levied the fine. So again, be mindful, and I see this mistake all the time, boards thinking that just because they have adopted a list of charges that they don't have to have a meeting and vote on these fines by per lot or individual. So something to be mindful of. Now, once the board has levied the fine and determined the dollar amount, it goes to a fining committee for approval or disapproval before it can be imposed. So it's important to note that the fine, once it's levied by the board, does not yet go into effect. A letter needs to be sent to the owner that advises them that a fine has been levied, but however, before it will be imposed against them, that the fining committee, which is an independent group, will have to hear their case, or they'll have an opportunity, I should say, to present their case, and that letter will give them the date and time and the location of where the fining committee is going to meet, so that that person can show up and make a statement if they so choose. They don't have to. And that has to happen, that committee meeting can't happen less than 14 days from the notice. So it needs to be a 14-day notice. So again, to recap, board levies the fine, a notice of 14 days advance notice goes out about the committee meeting, and that committee is the one that gives the final approval or disapproval. That fining committee has to be at least 3 members, and they cannot be anyone who are officers, directors, employees, family members, or family members of any of those people. And the reason is the legislature wants this fining committee, who's the one making the final call, to truly be an independent group from the people who originally made the decision to levy the fine, the board of directors. So it's important that you make sure that your fining committee is properly comprised of those individuals who are allowed to be on it. Other committees of associations don't have this type of restriction. This is the only committee, other than the people who count votes at the election, this is the only committee that by law cannot have board members or their family member, co-owners, affiliates, etc. So very important. Another important distinction is, for example, let's say you have a 5-person board of directors. If at a board meeting you have 3 of your directors show up, you have a quorum. You can still hold your meeting. And if 2 out of 3 of the quorum vote yes for a motion, for most motions, that's going to be enough, meaning a majority of quorum. Keep in mind, that is not how this statute is written for fining, meaning if you only have 3 members, if less than 3 of them show up to the meeting, if let's say only 2 of them show up and they both vote yes to fine someone, that is going to not be a valid fine because the hearing has to be held by statute before 3 members. It doesn't say before a majority of the committee or just before the committee. It says before at least 3 members have to hear have to be there for the hearing. So again, I've had attorneys argue that, and it's a good argument, quite honestly. So be careful. So some communities, they will have what they call alternates, or they'll just have a 4 or 5-person committee so that they never run into this issue of having less than 3 people. So again, something to be important, something to be mindful of. Now keep in mind, the committee, their authority is to only say yes or no, approve or disapprove the fine that was levied by the board. They cannot make modifications. They can't say, well, instead of $100, let's make it $50. They do not have that authority. It is purely, they look at the file, they listen to the individual if they show up in their own defense, or if they're allowed to bring someone else who maybe can help their defense, that's allowable. The committee can then just say, okay, yes or no to what the board did. If the committee does not approve the fine as levied by the board, it cannot be imposed. The board cannot overrule the committee. Otherwise, there'd be no reason to have this committee. If the committee could say no, and the board could just say, well, forget you, we're doing it anyway, it would render the committee role pointless. So, again, the committee, if they disapprove, fine cannot be imposed. If the committee does approve of the fine, you must send the person, again, another written notice. So you've now sent them the warning notice way back at the beginning. You then, after the board levied the fine, had to send them another notice, the first required notice, which was the 14-day notice of this committee meeting. And now whatever committee decision is made, you want to send, even if it's a disapproval, the notice should still be sent that advises the person of the fine either being disapproved or more commonly approved. And if the fine is approved, it's important to note that can't be put on their ledger or demanded payment from them until 5 days have passed from that sending of the written notice. So it's an important distinction. It should not be put on the ledger the next day. Again, it's not due until 5 days after whatever date that notice is sent. We just talked about this. I just covered this slide as far as the fining committee's scope, so we'll skip over that. Now, you've levied a fine. Congratulations. You've gone through all this procedure, and what can you do with it? So let's say Mary owes $100 or Joe owes $1,000 because it was continuous up to the max. What can you do? Well, in a condo, a fine can never, ever be used as a lienable amount of money, meaning, we're all familiar with if someone doesn't pay their assessments, you can put a lien and you can foreclose that lien, and they could potentially lose their home or their condo if they don't pay their assessments because you have lien power. That's a really good enforcement tool because people don't want to lose their home over small amounts of money. So when you threaten that, that is a very good way to get people to pay their unpaid assessments. Unfortunately, in a condo, you can never do the same thing with fines. So basically a fine, as far as collecting the money, will sit on the ledger unless you decide that you want to file a lawsuit for a money judgment against the person, which again, if they only owe, let's say 100 or even 1,000 on a fine, suing them for a money judgment, in some instances, the filing fee that you pay to the court is going to be more than the money that you're going after. So I don't know of any association that ever pursues money judgments. What they do in condos is more commonly, if the owner doesn't pay, they leave it on the ledger, and they'll, and again, we're talking about collection because there are other things that these debts impact on, but when it comes to collecting the money, it's most commonly collected when that person goes to sell their condo. It'll be on the estoppel letter, and if they want to sell their condo, they got to pay it. And at that point in time, usually they want to just get their sale done, and they're not going to, they may put up a little fight, but they're not going to lose their sale over $100 or a few $100s. So that's where you can commonly get the money. And in HOA, it's almost the same, except that if the fine gets to $1,000 exactly for one of those continuous types, you can actually lien for that amount of money if the governing documents allow for it. Now, to be clear, that doesn't mean if they have a $100 fine for landscaping and $100 for a dirty roof and $100 for a driveway, you can't cobble them all together to get to 1,000. It has to be one violation that went all the way to 1,000. And actually HOAs, if your governing documents allow, you can have a max that's more than 1,000. But as long as it's 1,000 or more, the 1,000 is the default max by statute, you can lien for it in an HOA if your documents say the same thing, which a lot of documents do. And we've done that. We've had HOA clients where they do have a violation. It goes, let's say $100 a day for 10 days. And they send us the file and we treat that $1,000 like an assessment and we lien for it because the documents allow us to do that. So again, that's really how you collect. But what else can you do with it? Well, if the debt becomes past due for more than 90 days, then you can suspend access to common elements and amenities, and you can even suspend voting rights. Additionally, the person, if anyone owes a fine in an HOA, they are not eligible to run for the board. In a condo, it has to be only an unpaid assessment, but in HOA, if they owe anything at all, they are not eligible to be a candidate for the board on the last day they could nominate themselves. So that's another important distinction as far as eligibility goes. And then, of course, if someone's on the board, whether it's condo or HOA, if they happen to get a fine when they're on the board, which they really shouldn't, or they maybe got one right before they got on the board, if they don't pay it, 90 days pass, then they are basically deemed to be kicked off the board. They've abandoned their seat, and unless they pay the fine and their fellow board members decide to reappoint them, they are off the board. So, like I said before, collecting the money is a bit challenging, but there are other penalties for people who have fines, as indicated here on this slide. Now, keep in mind, I talked about suspension of use rights when the fine is not paid for 90 days. Those are for things like the pool, the gym, laundry room, clubhouse, amenities. And they're not for, and this is by statute, things like common areas used to provide access. So in a condo, if we have a grand foyer and maybe a club room that's open concept to where the elevators are, you can't tell people that they aren't allowed to go through the lobby in that open club room because they have to be able to have access to the elevator. So it's very important that they have that, and you can't take that away. Now there's arguments about impairment. You can't take away things, but what about making it more difficult? And that's where we come up, means of ingress and egress and things like that. We talk about HOA gates. And I will say that it is a controversial remedy, but one that is potentially viable to tell people that they have to go through the guest line, meaning you turn off their RFID sticker or fob or whatever it is to go through the resident gate, and they got to wait in line with all the other vendors and guests to get into the community. Highly effective at getting people to pay off their fine or any other debt, but also highly controversial. And, you know, there's some people that say you can't do it at all. There's some that say, based on the way the statute's changed over the years, you can. I do see it commonly used, not commonly, but often used in HOAs. I did have someone in a condo once, interestingly, try to make an analogy that said, well, if in an HOA they can make it more difficult for someone to get into the community, why can't we do that in a condo and say, instead of them taking the elevator, that they don't get the benefit of the elevator, they have to take the stairs? And I said, I like the thought and the analogy, but I can imagine that that would never fly, especially in a high rise. That's going to certainly be deemed an unreasonable burden, and probably, where I said the other one, an HOA, is controversial, this would be extremely controversial. So again, people get creative and push the envelope. I always advise, you know, I'll give them the option, but tell them the ups and downs. Another thing, utility services. If some communities, let's say, bundle into the common expenses the water bill. Everyone's water bill is just paid by the HOA or the condo, and then it's part of your maintenance. If that's the case, you can't shut off the water to the unit or the electricity. As the world is developing, there's more of a push that cable TV, and more so even internet, be deemed to be an amenity. I'm sorry, not an amenity, a utility. And there are some companies, I know, for example, Hotwire, they allow HOAs or condos that use their service. You can call them up and say, hey, shut off unit 202 services, and they will do that for you. Just like with the other one, very effective at getting people to pay their bill, but very controversial, especially in this day and age, internet, where people are telecommuting or they're doing telehealth visits. Very controversial to take away people's internet, that even if they aren't paying their bills, including fines. And then another one you can't suspend is vehicular and pedestrian access, including most notably the right to park. I've had condos and HOAs ask me, when people owe money, hey, can we take away their parking pass? The answer is no. So these are things you can't take away. Again, it's mostly more of amenities or things you can take away. And of course, this is just some of the same information that has to do with taking away people's voting rights, and taking away their interest in that, as far as membership voting. And you can take away people's voting rights, but unlike suspending for amenities, it has to be at least $1,000. It does still have to be unpaid for 90 days, but you have to also give them advance notice. So again, if you're going to take away voting rights, the law looks at voting as more sacrosanct. So they want you to have a bigger debt and give warning before you suspend it. Whereas suspending of amenities, you can go right to a board meeting and suspend people's amenity access, even if they owe $1 for more than 90 days, and you do not have to give them this 30-day warning. To me, I think the legislature kind of got this backwards, because I think your owners, especially those who are not paying their bills and fines, I think they care more about their use of the facilities than they do necessarily about their right to vote. But in any case, this is the way the legislature came down on that. Now this, and we're getting to the end of my part here, this is the most important slide. and these are the defenses to enforcement of fines. The first one, and this goes back to the first slide where I talked about uniformity and timeliness. So the first defense we commonly see, and you guys all probably hear this at some point when someone gets enforced against, is selective enforcement. The why me argument, because so-and-so did such and such. And so it's important to know when people start to make those arguments about selective enforcement, there are some elements that have to be there for it to be viable. The first is sameness. It has to be apples to apples. If my association is enforcing against me because I am parking a vehicle that I'm not supposed to have on the property, I can't say they're selectively enforcing because they let my neighbor have a dog that they're not supposed to have. Again, they're different things. So a totally different violation does not create a basis to argue selective enforcement for something that I'm doing differently. So again, in that example, if I could point to other residents that had a similar vehicle to what I had that I was being enforced on, then I would have a viable selective enforcement argument. Now, the second argument is recency. So it not only has to be apples to apples, but it has to be somewhat recent. I once in West Palm Beach had a 55 plus community, and we were enforcing against a 38-year-old woman who was living in the unit by herself. And we told her you're not allowed to do that. And her lawyer produced some sort of document showing that 21 years prior, a 30-something-year-old person had been allowed to stay by themselves in a unit. And I explained to them that that is not a viable basis to argue selective enforcement, because as far as the law and the world is concerned, 20 years is ancient history. So that did not fly again. So they can't look, to ancient history to find a basis for apples to apples different enforcement. And then finally, knowledge. That means that, let's say someone, and this is an example I've had, we enforced against someone that had an oversized patio. Their neighbors saw in their backyard, they had extended their patio. The community had very strict size restrictions, and they came to the association and said, well, I know 3 other people that increased their patio size. And we said, well, who are they? And they gave the addresses. And look, these patios are in people's backyards. Unless someone reports it, we don't necessarily know. So I explained to them, thank you very much. We're now going to have to pursue action against your neighbors. But the existence of them having that doesn't get you off the hook, because the association had no advanced knowledge of it. And now that they do, they're going to treat everyone the same, and they're going to pursue them the same as they're pursuing you to resize your patio. So that's selective enforcement, and that's a big one. And those are some tools for you to combat owners or others that are trying to say that you're selectively enforcing. Another issue that was brought up is waiver. That's basically, it's also sometimes referred to as a estoppel. That's one of those arguments that, well, it's been a little while, I've had this, I've done this thing or had this situation, and you didn't take action, so you're not allowed to do so now. And there's plenty of arguments against that. There can be what's called a savings clause, is common in declarations that says something like the failure to enforce does not constitute a waiver of enforcement in the future. Again, another one that's similar to that waiver argument, but more serious, is statute of limitations. If you've waived or let something go for so long that it's been more than 5 years, the owner who you're trying to enforce against will now have a potential statute of limitations argument. The statute of limitation in enforcing your documents is 5 years from when you become aware of a violation. So in one community, it happens more than once, but just an example I can think of, again, a guy had put in, he had widened his walkway, which was specifically a violation, but he did it 10 years prior, and the board wanted to take action. Now remember, these are defenses, they're not bars to taking action. So we sent that person a letter, and I will say to their credit, they hired counsel, and the first thing they stated was, This has been like this for 10 years. The prior boards were in touch with the owner about it, but they never decided to take action. And because it had been more than 5 years that the board was well aware of the violation, that if the association proceeded to a lawsuit, they were undeniably going to be unsuccessful because of statute of limitations. So that's one you don't want to sit on your hands for too long because that can come up. And sometimes governing documents may even narrow your own statute of limitations. So again, something to be mindful of, that they could be less than 5 years if your documents so provide. Finally, the biggest issue I would say I see, even bigger than selective enforcement when it comes to enforcing fines, are procedural missteps. And that's all this procedure I described earlier. The law, and there's case law that says that the statute has to be followed to the T. And especially there's case law on the fining statute. And missing a day in that 14-day notice, or not having a board meeting or a committee meeting, those can all end up being very fatal to your desire to enforce your fines. So, it can be very confusing as far as what process to enact. It's definitely something, if you're unsure, you should talk to the association attorney because your documents need to be read in conjunction with the statute. And older documents usually contain a lot of conflicting procedure with the way that the statute now works. So you kind of need to, the attorney needs to put those things together for you to give you a clear picture of what to do if you're not sure. So with that, that is the end of the presentation. I only see 73 comments here. So actually, I don't know how you want to go through the question and answer section. What would you like to do?
So what you can basically just go through it, any that you want to answer, you can answer live. That's how, we typically conduct those. I will go ahead and launch the poll now. So if anybody does want to jump off and doesn't want to stay for the Q&A, we can get their feedback. And I do have a list of the attendees. And if you registered, you should have put your CAM in there. I'm going to send that over to Dan after via email. That way you guys can issue the credits for everyone. I will be sending out everything after the webinar via email. So I have the presentation, I'll send the recording, I'll send Dan's contact information. So if you have questions about the CUs, since his office is going to be issuing those, not us, you can reach out. But other than that, I will launch the poll right now, and I'll just leave this open, and you can go ahead and just, scan through the Q&A and answer them live, any of the questions that you find applicable.
I'm going to go through. I see they're adding.
Yeah.
So
I knew that was going to happen.
Yeah. So we'll answer some of them.
Yes.
And then what I'll do is I'll answer maybe for about 20 or 30 minutes. I'll try to go through, and then we'll go from there. We'll see.
Perfect. Perfect.
So
awesome. Thank you so much.
I just like rapid fire. Now we were at 73. Now we're at 88.
Yeah. No, 91.
Oh God, yeah. So yeah. All right. When can a fine begin? When a violator has been told they can be fined only after a fining committee is approved. Okay. So a fine I say the clock starts when the violation happened. The most conservative thing is to start the clock after you've gone through all these processes. But by that point, to John Pierce, I can't see his last name, I'm assuming Pearson maybe, to John's question, the most conservative route is wait till you go through this whole procedure, but then they can just cure the violation, and now you've done all this procedure and they've cured the issue. Even if they do that, you could still, I think I take the position that the clock starts to run when the violation behavior occurred, and it continues to run until it stops. So like, let's say someone leaves out the trash cans. If they leave them out for 5 days, then they bring them in, and then you have your whole committee meeting, your board meeting, committee meeting. I think you can fine them for the 5 days. And then if it happens again, you do have to restart the whole process over again because they brought them in. But again, I don't think they get off the hook every time just because you're in the midst of the procedure. One says they voted by, next one, board voted on fines via email and doesn't always include fines in the public meeting. Can they be challenged? Yes. Jumping ahead, for repeat infractions, do you need to begin the fine process each time? Yes, you need to begin it again each time if it's something there's a break. In that example, it's parking a trailer, which was not allowed. If they park the trailer and then they move it, I do think you can still fine them for the time it was there. But then if they bring it back a week or a month later again, you do have to go through the whole process all over again to levy another fine for however long the trailer was there. I think that for repeat offenders, if you've already gone through it once, that you should be able to not have to go through the whole thing again. The legislature disagrees. Does the PC county have a noise? I'm not sure what PC county is. Maybe they meant PB, Palm Beach. Have a noise ordinance you can enforce if your documents don't address noise. Your documents probably say something about no illegal activity in the section, what's called use restrictions. So if you don't, even if you don't specifically address noise, if your documents have a section that say no illegal or immoral behavior, and they violate the county ordinance, that would be illegal behavior that's enforceable. Even if pit bulls are allowed in our declaration, can a resident still get a letter stating that an emotional support dog can be allowed? Absolutely. Any dog, it can be a Great Dane, a Rottweiler, a pit bull. Doesn't matter if there's county restrictions like Miami has on pit bulls. Doesn't matter if there are restrictions in your documents on breeds. All that goes out the window with an emotional support animal. There's another question on the paperwork for support animals. I'm not going to get into that on this presentation. What is the required process before enforcing a monetary fine from a tenant or owner? Are letters required? Once you've levied the fine, to enforce the monetary process, if you want to pursue the debt, you can send a demand letter for them to pay. You can threaten to file a lawsuit, and then you can file a lawsuit. That's after you've already done the whole process and the fine is now in play. If you don't want to wait for them to sell the home to collect your money, you can send a demand or go right to a lawsuit. But I don't know any association that really does that because they're usually not, the money is not worth it. When a homeowner has a tenant who's breaking the rules, do you find the homeowner or the tenant? I recommend finding the homeowner because they're the ones that have a vested interest. And, you know, good luck chasing the tenant for $100 or $500. The owner is the one we pursue and we recommend. What if the board doesn't enforce the rules uniformly? I think we addressed that. This next one is talking about a board entertaining a restriction about owners having to use a service elevator for pets. They're talking about a notice for this rule. Yeah, they're asking about since the proposed rule isn't a restriction on a unit, could it be done with a 48-hour notice? Yes, that rule could be done on a 48-hour notice. That's Steve's question, but I don't recommend doing that until you've consulted with the association attorney, because treating an emotional support dog differently and that the owner has to go in a different elevator is somewhat controversial. If closed circuit TV is used to support a fine, does the video or photo become an official association document? The law is moving in the direction that if you have surveillance video that's retained, that's written to a disk, that is considered an official record of the association. If you're going to use it in supporting a fine, then it absolutely becomes an official record that is inspectable. Is a meeting required for every fine that will be issued? Yes. Does the name and address need to be on the agenda? There should be some identifying information on the agenda. Do we used to do this before backwards? I don't know what you used to do, so I can't answer that. How much detail should we put on the agenda? Just a minimal amount to identify the person or the property associated with it. Sometimes, you know, they'll say, you know, owner of lot 32, so that it's, you know, give some degree of anonymity, but quite honestly, if you're worried about enforcement, I would put the owner's name. There's nothing private about this process, about going through a fining process. Our docs do not put a limit on fine, but say they can't be over 1,000. Is that legal? Yes, it is legal. However, a one-off violation or fine can't be more, or if it's continuous, it can't be more than $100 per day, or if it's one-off per incident. So if your documents say that it can't grow to more than 1,000, it doesn't mean that you can, if someone has a party, that you can just levy $1,000 on them. You can only do 100, or if it's, again, let's say leaving the trash cans out, the max per day is 100. So, you know, that's by statute. First issue, the grievance committee meeting, 14-day notice, and then the committee, I'm not sure what that question is. I'm going to skip over it. If you have a subdivision board and a master board, can you appeal at both levels? It depends who's fining you. If they're both fining you, they would both have to give a committee present before they impose the fine. Each one of them would have to have their own committee. But if you're being fined by your subdivision, the master association has no role in that. Some of these are redundant, so we'll keep going. What if you don't have a committee in place? Can a fine still be imposed? Absolutely not. Now, what I've seen associations do, and what I've done for them, if you don't have a fining committee, you can still threaten a fine. Doesn't mean you can't threaten a fine, because at any point you could get a committee together. So you could say, hey, if you don't get your act together, we're going to fine you. But you can't actually fine someone unless you have a committee. 100% required to have a fining committee by statute to impose a fine. You don't have to have a committee. If you don't want to impose fines, you don't need to have a fining committee. But if you want to impose fines, you have to have an independent committee. Some of these were answered. How is the committee formed? The committee is formed by the board. They vote on the individuals. They appoint the individuals to the fining committee. Is there a fine greater than $100? Not per day or per incident. No, that doesn't. The statute doesn't allow that. One question, this is an important one. Can we confirm that the person being fined will attend the committee meeting so the committee doesn't have to gather if the violator doesn't show up? The answer to that, no. The committee still has to convene even if no one shows up, because the way the statute is worded, it says a fine levied by the board of directors cannot be imposed unless and until there's been an opportunity to appear before the fining committee, and the committee has to approve the fine. So if there's never been a committee meeting at which they approve the fine, that fine is not valid until it's approved by the committee at a meeting. Question, can the grievance committee also be the fining committee? I don't recommend that at all. The fining committee by statute has a very limited purpose, which is upholding or denying the fines that are levied by the board. Years ago, you could let them be the same. I do not recommend that they be the same people. The people who are initially identifying grievances or violations or hearing from people should not be the same people at the end of the equation who are voting yes or no. So again, I don't think that's an advisable setup. So I would separate them. The definition of a quorum when it comes to a board or a committee is a majority. When it comes to a definition of a quorum of members, that's going to be governed by your governing documents and the statute read in conjunction with each other. So that's quorum question. If the board levied a fine and activity restriction, but did not send a letter about a fining committee to the violator, can the fine restriction be upheld? No. If you didn't send the notice, the 14-day notice, let alone the letter after the fact that they were fined or suspended, both of those are fatal to the process. This is where I talked about earlier, procedural missteps. So we're coming up on a lot of them. Can participation of the fining committee be over conference calls? Yes, it can, as long as there's still a physical location for the meeting to be held. A fining committee, unless your documents provide for it, is not a private meeting, especially in a condo. So, there's now you could have a situation where, let's say, the property manager shows up, has the phone, and all 3 committee members are on speakerphone, and maybe a couple homeowners or the people who are being fined physically show up. That's perfectly fine. But again, it can't just be the 3 individuals on a conference call or a Zoom. That worked, Zoom only worked under a state of emergency, but unless your documents allow for purely electronic meetings to be held, which most do not, now that we are well past the COVID state of emergency, as far as the governor's declaring of a state of emergency, there does need to be a physical place for committee and board and membership meetings, although Zoom can be an option, or teleconferencing in for the committee members can be an option. Let's see, that's done. Yes, there can be more than 3 members in the committee, but they got to have at least 3 present at the hearing. Let's see. Some of these, one of these was like, what happens if someone was fined for a dirty roof and they cure the roof on the 8th day of a fine, of 7, if they cure it on the 8th day, you can still go forward and fine them the $700 for the 7 days that they had the violation. Now, if you gave them a 30-day window to cure and they cured it within that window, that's different. But if outside the window to cure, they had another 7 days, and the board can say, even if it's a couple weeks later, this happened outside the cure period, it lasted for 7 days, we're going to fine $100 a day. And then it would go to the committee for them to uphold. And look, the owner's probably going to show up and say, well, I fixed it. And then the committee decides, do we still want to fine them anyway because it happened or not? Should meeting minutes be kept? Absolutely. If an owner is a no-show, is it automatically a fine? No, not necessarily. The committee still has to review the matter and make their decision. I have seen once in a while a committee, even when the person doesn't show up, they felt that the fine was inappropriate and they did not uphold it. If you don't have a quorum at a meeting, can the members present do a phone call the next day? No, you have to reschedule the meeting, again, on 14 days notice. Can the committee give additional time to cure? No, they can only uphold or reject the fine. No modifications, no grace periods. It's just a yes or no, no changing the dollar amount. We're a small HOA and have not been able to get volunteers. So any options? Unfortunately, no. If you want to have fines, you got to get that 3-person committee. So yeah, in very small communities, it can be almost impossible, unfortunately. Let's say you want to have 5 people on committee, you get 20 volunteers. Who decides? The board. I'm trying to scroll down here. If the fining committee does not approve the fine the board asked for, can they come back with their own recommendation? No. Does the fine begin immediately, or can it not start? That cannot start until 5 days after the notice of the fine being approved has been sent to the owner. So if you had your committee meeting today and 3 days from now is when your manager sends that person the notice, they have to wait another 5 days from 3 days from now, or 8 days from today, until the fine can be charged, can be considered due. Can interest accrue on fines? Without getting into some nuances, no. Can you hold an owner responsible for fines levied on a tenant or a guest? Yes, we talked about that. Let's see. Can you put unpaid fines on credit reports? You can report to credit agencies, but I don't recommend doing that, especially for fines, since fines are more subjective. I quite honestly don't know any associations that even report unpaid assessments to credit bureaus, which are more objective. I don't think it helps in this setting. I don't think it's a useful tool, and that's why no one does it. So something to be mindful of. Co-ops, are the rules the same? Yes. Can you do a rent demand to collect on a fine? You absolutely can. If someone owes a fine, you can, and they have a tenant in their unit, you can send a demand asking for the tenant to pay over the rent to cover that fine. Let's see. Some of these are just general questions, which I'm going to have to skip over, unfortunately, just for time. Should we send certified mail when residents are fined? You don't have to. I would recommend, though, if you have an issue with people saying they don't get the letters, to be safe, I would send it, if you're going to send it certified, send it certified and regular mail. So that way, if they say, well, I never picked up the certified letter, at least you have now sent it a regular mail way too. So we always send everything certified and regular, so they get duplicates. But that way, if they say they didn't get one, it makes it look pretty bad. It's like, well, we sent you it 2 different ways. So, you know, we're pretty sure you had to have gotten one of them, or you're just disregarding it. Who should be sending the warning letter? Management company, BOD, attorney. Most commonly, the management company sends the warning. If a resident has 4 more speeding violations, we suspend their transponder to go through the resident gate. Is this okay? I dealt with that earlier. Assuming an association doesn't have Kaufman language, can the condo still rely on it? No. If the condo doesn't have what's called Kaufman language, which again, I won't go into the legality of it, they would absolutely need provisions in their governing documents giving them the right to fine and spelling out the authority. So it's important to consult with your attorney on, again, on your authority before you start fining people, whether you can fine and what version of the statute you're subject to. We don't have a fining committee. Can we bill the owners for the cost of handling the violation? Well, you can definitely, if people, for example, we had a person that drove into the gate of the community. They were immediately allowed to send that person a demand for the cost. Or sometimes when people, you know, put trash in a compactor that they're not supposed to, if it causes an extra charge or incurrence of expense, you can definitely pass that along right away. But you can't, you can additionally fine them, but you can't just go right to a fine. But any cost out of pocket or expense of fixing something, in addition to a fine, which again has to go through this whole process, you absolutely can send them a demand for that immediately. If you turn off or you suspend someone's use of the pool due to overdue fines, can you demand they turn in their pool key? You can. Otherwise, I will tell you, it's very hard to, suspension of amenity use rights is very hard to police, because even if they turn in their pool key, they could show up to the pool and one of their neighbors just lets them in. So while it sounds good in theory to suspend amenity access, even when you have a fob system, you know, it's very easy for people to circumvent. And, you know, quite honestly, it's a remedy that sounds good in theory. The members of the fining committee have to be owners of units, yes. Turning off transponders or barcodes and having them go through the guard lane is allowed. That's a question. I referenced that earlier. Let's see here. What else? Just reading through some of these. In a no pet building, a resident can bring their pet and agree to pay the $1,000 fine, and that's it. We have no right to insist the pet is removed. Absolutely not. You can fine them if they have a pet that's not allowed, assuming it's not an ESA, and you can fine them up to the max of 1,000. Then you can start over and issue a new violation for the same behavior and fine them all over again and keep that cycle going. But sometimes that's not, fining isn't going to get the job done. Sometimes you need to send it to the lawyer and you have to have a lawsuit for injunctive relief. That is sometimes what you have to do. And in that example, if fining isn't getting the job done, you send it to the lawyer. A lot of times clients will send it to me right away because they don't feel like the fine is going to get compliance. So remember, if someone pays a fine, that doesn't necessarily mean they're going to stop the behavior. So sometimes you do have to take that additional step of having the lawyer send a demand and then go through potentially a lawsuit for injunctive relief. Does the board have to meet to suspend the use of amenities, or does it happen automatically? The board does have to meet to suspend amenities if it's been more than 90 days. How would you suggest to start enforcement of violations if the new resident board took over? There's a process for that that involves grandfathering in of violations and sending a reinforcement letter. So that's something I've done for many clients. It's something to consult your attorney on. Let's see what else. The maximum fine is $1,000, except that in an HOA, the members can vote to increase that to anything as a maximum fine. Some of these we talked about, taking away amenities. My association has a unit owners committee. Can the board overrule their decision on a fine? No. If they disapprove of the fine, the board cannot overrule it. Now, if the fining committee approves of a fine that the board levied and the board wants to then make a deal or something with the person who was fined, they can then do that after the fact because, their fine was approved. They can always, the board can always take less money there. But what they can't do is undo a disapproval. The board can present the fine again. The board can have another meeting, re-vote on the same issue. If it happens, I'm saying if it happens again, and then hopefully the committee, if it happens again, the same behavior will address that. Let's see a note here. It says removal of a board member that owes money is only maintenance, not other fees. That's not accurate. It's any monetary obligation, especially well, in an HOA. It is. When it comes to condos, that's correct. Do violation letters need to be certified? No. Do I recommend raising the max fine to over 1,000? Remember, that's only viable in an HOA. It depends on your circumstance, but it could be. I would tell you it's relative to your community, because I have some communities that are country clubs where the quarterly dues are $6,000. And so a fine that only can get up to $1,000 for the people that live there, that's sometimes it's not enough. But if I have communities where the dues are $100 a month, when you start to give the board authority to levy fines that can go upwards of, let's say, $5,000, that's going to be controversial. Let's see. I've been told in a 55 plus community, you have to allow 10% of the residents to be under 55. That's not true. You said in order for the lien, to lien, the fine had to be over 1,000, but your presentation said under. I don't think the presentation, I'm pretty confident it doesn't say that. It has to be 1,000 or more. And I'll check that to make sure, but I'm pretty confident it says 1,000, that anything under 1,000 cannot be a fine in an HOA. I'm sorry, a lien. The 14-day notices do not have to be certified. In a condo with only 52 units, can the board act as the committee and the board? No. Can people with prior violations serve on the committee? Sure. Although if they have unresolved violations, I would not recommend the board appoint those types of people. Let's see. I have an association that has allowed personal items in a common area in a condominium, and the board would like to enforce this. Again, if you've had a history of non-enforcement and you're now trying to say that you'd like to enforce, there's a procedure for that. It's a case law driven procedure, and I've done that for many associations, but that's something you have to consult with the lawyer or me. If the homeowner pays the fine, that wasn't finished. Once a hearing has been conducted, does there need to be an additional letter stating they are being fined $1,000? Oh, that's from Southbridge. That's from Karen. Once the hearing's been conducted, yes, there has to be a letter that says that they are being fined, and it should say the dollar amount, and it should also say that this amount will not come due until after 5 days from the date of this letter. If the homeowner and HOA fails to respond to a notice of violation, but the violation is clearly not within the statute of limitations, is that homeowner still responsible for the fine? They are still responsible because statute of limitations is not a bar, it's a defense. However, if the association goes to enforce that fine, the owner could sue the association for fair debt collection violations and defensively could defeat the fine there. Okay. Trevor asks, so basically nothing should be implemented unless the docs are good. Board sets the fine amount per occurrence, so basically set up a recurring meeting for the rest of our lives. Yep. If you really want to levy fines on the regular basis, they should be part of your monthly meeting as just a regular agenda item. Or if you want to have a separate meeting just for fines, you would have a meeting for that. If the homeowner pays the fine, but the violation hasn't been cleared, what else can the board do? That's what I talked about before. Fining is just one tool. If that's not getting the job done to get compliance, then what you're going to really need to do is send it to the attorney to demand compliance and then potentially file suit to compel compliance. And unfortunately, that's something we have to do sometimes. People, whether you find them or not, even if you find them multiple times, they still don't come into compliance. So sometimes you need a judge to tell them that they need to do that. Let's see, the slides will be available. I know Ashley's going to make them available. Let's see what else. My HOA has given blanket authority to the property manager to fine without board approval. They only vote on the rare occasion. I will tell you that if any of those fines are challenged, that association is going to lose. Can committee meetings be done by Zoom or in person? They do need to be, there needs to be an in-person location, but Zoom can be a viewing option and a participating option. Let's see. Some of these questions again are, when does the fine begin to accrue? Again, I would tell you the more aggressive approach is the fine begins to accrue the first day that it was noticed up until it's cured or until you reach the maximum amount of money. The more conservative approach is to not start accruing the time until the board has levied the fine. And the even more conservative approach is to not start accruing the time until the board and then the committee have both approved of it. But I take the position that the fine starts when the behavior started, except if you give a cure period. If you give a window of time to fix it, then arguably, what I recommend is start the time after that cure period. But you could even say if they don't cure it within, let's say, 30 days, you can go back to day one and say, well, they didn't cure it. We gave them a window. So now we're going back to day one, and that's when it started. So I think you can run it from them. Someone wrote a Florida statute, the primary statute for HMOs. No, not for HMOs, but I think you meant HOAs. It is the primary statute for HOAs. If someone pays the max fine, but they continue to commit the same offense, oops, sorry, I missed this here. Can they be fined again? Absolutely. You can, even if it's the same condition. Someone has a dirty roof. You do the whole procedure. They get fined $1,000. Roof is still dirty. You can send another violation, do another fine, another $1,000. Keep going and going. Or if there's a gap in time and then they do something again, you can do another fine. The only caveat is you have to go through the same full procedure. There's no like repeat offender shortcut that you're allowed. Unfortunately, I think there should be, but there isn't. Are board members individually held accountable for fines imposed on the members that were improperly fined? No, not really. If they were doing their job properly and they fined someone for something that maybe legally they shouldn't have been fined for, or there was a mistake of fact, then that's just, you know, that's just part of their business judgment. And if they made a mistake, you know, they're protected by directors and officers insurance. So even if they did get sued for that. Let's see, moving on. Should the compliance committee be checking to see if violations are still not cured right before the meeting? That is a good practice. You know, it's a good idea before the board votes on it, and then especially, you know, and before the committee votes. It is a good piece of information to know, hey, has this person done the right thing? Have they cured the issue? Because that may weigh upon the decision making. Let's see. Can the fine accrue late fees? Again, with a nuance distinction that I won't get into, no. Where would you place the fine in your accounting? On income? No, it goes on, it's on whatever you put your delinquencies, your debts. The fine is a debt of an owner, just like an unpaid assessment. Do all rules have to have a basis in the covenants? No, they don't have to have a basis in the covenants. The rules just have to be reasonable, and they cannot conflict with something that's in the covenant. So if your covenants say you can have 2 dogs, you can't pass a rule that says only 1. Is there a limit on the number of emotional support dogs? Unfortunately, no. But again, they have to be able to, for each dog, they have to be able to show a distinct need. Again, some of these are just general legal questions, so I'm not able to answer all those today, but I'm happy to answer them, you know, for anyone that would like our help. Let's see. A lot of these we've now answered. Can a compliance committee meeting be closed to other owners? They shouldn't be. In a condo, they can't be, unless your bylaws specifically say that the fining committee is closed. Otherwise, they should be open with meeting notice and minutes. Let's see. Do you have a sample menu of charges? I've had some of my other clients, I really let the clients adopt that, because every community, their issues that they have are different, and their dollar amount that they want to charge for them, it's really a community specific thing. So I really leave that to the communities. We have some of them the communities have developed, and we've helped 1 or 2, you know, but again, that's really more for your community to determine. Are you going to have a class on condo reserves in the new condo law? I actually have a approved CEU course for the new condo law, and I hope to have a class on it soon. Is the HOA responsible for attorney's fees to a homeowner if the homeowner prevails? If there's a lawsuit and the homeowner prevails, most likely. If you don't have a fining committee, it can be turned over to the association attorney. It can always be turned over to the association attorney, whether you have a fining committee or not. And again, we talked, sometimes these fines just don't get the job done, whether you have them or not. So, it's something that if you have someone that you really, the fine isn't compelling them to comply, then you really don't have a choice. You got to send it to the attorney. Is the first violation letter the person sent before or after the board levied the fine? The first letter, the warning letter, would go out before the board has their meeting if you're sending a warning. If you're not sending a warning, then the first letter that the owner gets would be after the board levies the fine, telling the owner about the 14 days notice for the committee to hear from them. So all three members have to approve the fine. No, it can be 2 out of 3. It's a majority approval of the board, of the committee. It just has to be all 3, at least 3 committee members have to be present. But whether it's a committee of 3 or 5 or 7, it's just a majority vote to approve. So in that example, if you have 3 members, all of them are there, then you have a proper hearing. And if 2 of them say yes and 1 say no, then it is absolutely it's been passed. Okay, I think I'm only going to do a couple more here. Can the fining committee establish a payment plan? No, unfortunately. Can a committee table a vote to consider a future meeting? The committee can only table a vote if they are waiting for more information, but ultimately they can't do anything to modify or change the fine that was levied by the board. So eventually they're going to have to vote on it. But if they do feel that they need more information, they might, that it would be reasonable for them to table the vote. Can you take the fine owed out of the HOA fees? That's a little controversial. If someone sends in what's clearly their assessment fee, there's an argument that they shouldn't, that the fine amount, especially if they're disputing the fine, it shouldn't be taken from that. But then there's also the argument that just when people send in money, you apply it to the oldest debt first, and you apply it in there's a statutory order. So again, unfortunately, that's one that's kind of dependent on your documents. And I will say there's some nice thank yous and comments in here, so I appreciate that. Let's see. I'm sorry if some of you I'm not answering your question, but a lot of these are somewhat duplicates, or I'm just, for the sake of time. What if the resident never received the letter regarding the violation? All that's required is for you to put it in the mail. And that's why I like certified mail, because there's proof of tracking. So if someone says, well, I don't believe you sent it, and the manager, even if the manager signs an affidavit, at least the tracking helps with that. However, even if you don't send it trackable, as the law only requires that you send it. We're not the guarantors of the mail. We can't ensure that the mail is going to get to its destination. But look, if that's something the committee can consider, and maybe if they feel like there's a genuineness to the claim that the person didn't get any, they didn't know they were in violation, and the committee can certainly consider that. There's been questions about why do you need Kaufman language or a fining provision in order to fine, since the Tahiti Beach case holds that a fining provision is remedial. Again, as I said earlier, arguably you don't need it, and that's why I said arguably, and that's the case. That makes it arguable, but it's best practices to have it in there, because then there's no dispute, and it just takes away an argument of whether you have the right to fine or not. If you just put it even in the rules and regulations, then you don't have to go into a a legal and case law analysis. It's right there in black and white, and it's something just the board can even do. So that's a couple of people have asked about why do you need it in there based on that case law. And again, that's why I said earlier, you arguably don't need it. What percentage of HOAs have a fining process? I'd say probably about 50% of them do. A lot of them don't because they either don't have interest or they don't have they don't have enough people willing to serve, or they found it to be an unrewarding process and rather just send it to legal than go through fining. But some of them find it to be effective as well. What if a committee member is in legal for collections? Can they serve? Yes, they can serve on the committee. But again, if you have people who aren't paying their dues or who are in violation, these are people who really, I mean, unless it's just a very temporary non-payment that they missed 1 month or something like that, it's something the board really should consider, maybe taking that person off of a committee. Can the board member be on the committee? They can be on other committees. They can't be on the fining committee. Someone's saying that I read the statute to say that you need to provide the opportunity to have the fining committee, but it seemed like it was optional. Unfortunately, the wording is not great, but the rest of the statute says that a fine cannot be imposed unless it's approved by the committee. So that sentence that says you have to give the person the opportunity is the word that's used to appear at a meeting. Yes, you have to give them the opportunity. They can choose not to avail themselves of it, but because of the rest of the language of the statute that says you can't impose a fine unless it's been approved by the committee, that is what makes that committee meeting mandatory, whether the person shows up or not. So unfortunately, yeah, you still got to hold these meetings, even if the people tell you they're not showing up. We have a resident who's a community activist, always asking questions, keeps records going way back, always talking to other neighbors. How can we use fining to keep them in line? Well, fining is not a tool, unfortunately, to silence people. It's if they are doing something that violates your covenants, then that's what fining is for. If someone is just participating and they have information and they're talking to people, unless they're spreading factually false information, I don't read any of that to be a violation or finable. And quite honestly, if you tried to fine them, I think that would get you in some hot water. Let's see. What if the board did not vote to levy the fine? That's one of those procedural issues I talked about earlier. That would definitely create a problem. I think we're almost at the bottom here. The 14-day requirement is not less than 14 days. So it's within 14 days. So it's, from today, let's say, what's today, September 28th. If I was going to send a notice today to someone of a fining committee hearing, the soonest it could be would be October 12th, 14 days from today. How many violations get sent out before it goes to the board? That's up to the community, how many warning letters they'd like to send out. That's entirely up to them. I thought a board member can be a liaison observer, but does not vote, correct? I hate having liaisons to fining committees because it creates a perception of participation, even though they're not actually participating in the voting. They're not a committee member. I've had other lawyers argue that it puts, especially if they show up at the meeting, that it puts duress on the committee members, because it's like having, it's like imagine you're playing with your friends as a little kid, and imagine your mom or your dad are sitting in the corner watching what you're doing. You're going to act a little differently with mom or dad watching than you might otherwise would as a little kid playing with your friends. So I don't like for them to attend the meetings. If there is going to be a liaison, it should be that the chair of the committee reports to the liaison reports back to the board. But I really don't recommend having those liaisons. If a person is paying their maintenance but becomes delinquent to failure or fine, can they be sent to collections? Well, again, we talked about what can and can't be lienable. So with all that information, that would have to be, addressed. And I think that's about the bottom there. Okay. Well, we're going to cut that off. I appreciate everyone's involvement. I appreciate everyone's help and questions. I say help because your participation is what makes this a better presentation. Otherwise, it's just me talking to you for a long time without any interaction. And of course, on Zoom, it's at least better than, I always like to be in person, but at least this gives us some degree of interaction.
Thanks for watching. For more great educational content, click the subscribe button now.